Hello there, how are you doing? My name is Mutiawa Conrad. I'm a lawyer and a private law tutor. I'm also a practicing advocate of the High Court and all subordinate courts thereunder. In this video, we are going to be looking at the law of torts. And more specifically, we're going to be looking at a tort known as assault. In this video as well, we shall be looking at the definition of the tort of assault. We shall also be looking at the ingredients governing this tort. And within there, I'll be discussing for you quite a number of interesting cases governing those various ingredients. And also, as usual, I'll be sharing with you quite a number of legal principles which govern the tort of assault. So just before we start on our class, if you are not subscribed to my channel, I encourage you to subscribe. Just below there, below the bottom of this screen, there is a subscription button. Just click on it. And also do not forget to like and share this video with your colleagues so that they are also able to benefit. So let's jump right into the tort of assault, and we are going to be looking first at the definition of assault. Now, from the onset, friends, you have to note that there are quite a number of definitions of what an assault is. But we want to choose a definition which is all-encompassing in terms of having all the ingredients of the tort of assault. So for that matter, the best definition for you to use is that an assault is some direct and intentional conduct by the defendant which causes the victim reasonably to fear that unlawful force is about to be used onto their person. Now, there are very important take-homes in this definition, which you have to note. Number one is that the assault has to be direct. The aspect of directness is very, very important. Number two, the aspect of intention. There must have been an intention. And then also, the victim's act must have caused some reasonable fear that unlawful force is about to be applied on the defendant. So that aspect of reasonable fear being aroused in the defendant is also very important. So you cannot afford to leave it out in your definition. And of course, that reasonable fear, of course, has to be backed by the aspect of unlawful force. So let's now proceed to look at the ingredients of the tort of assault. Now, before we even go to the ingredients, friends, it's important to note that if you're a student and you're watching these classes and you are struggling, you need private law tutorial sessions, please feel free to contact us. Our numbers are down in the description box. You can always contact us. We can be able to help you if you're struggling, if you need an extra push. Please just contact us. Our experts are always available. We'll be able to hold private law tutorial sessions with you so that we are able to help you improve your grades. And students who have gone onto these private law tutorial sessions have continuously been proven to outperform their colleagues who do not have any sort of mentorship or private law session. So please contact us. The numbers are down in the description box. So let's go on now and look at the ingredients of the tort of assault. So the first ingredient we are going to look at is that the defendant's act must be direct and intentional. Remember when we were looking at the definition, we had already looked at these key aspects which we included in our definition. And now here we are again, we're saying one of the most important ingredients is that the defendant's acts must be direct and intentional. Now this is very important. Like I said from the onset, the aspect of directness and intention are fundamental elements that have to be in the first ingredient. So let's look at the aspect of conduct, okay? What have been some of the court decisions on the aspect of conduct? Now, traditionally, the use of threatening words alone could not amount to an assault. Okay, so if someone only used threatening words, traditionally this could never amount to an assault. For example, this was the decision in the case of R versus Mendy and Belt. It's a decision of 1823. Look it up. That was the holding of court. And to be more specific in that decision, court held that no words or singing are equivalent to an assault. So the decision of court was that if someone used words, that can never amount to an assault. But of course, this was in 23. However, in R versus Constanza, it's a case of 1997, volume 4, All England Law Reports, page 225. In that decision, well, it was a criminal law case for starters. However, court recognized that words alone could indeed amount to an assault. So that's important to note in that court decision. Whereas in R versus Constanza, and also in another decision of R versus Ireland, these are criminal cases, the likelihood that a civil court would hold so as well are high. So in essence here, what we are saying, friends, is that whereas that was a criminal law case, but it's very highly likely that even in a civil case, court could still rightly so hold that words are sufficient conduct to amount to an assault. So that's important for you to note. Then also words can also have the opposite effect by making it clear that the assailant does not intend to carry out the threat. So what we're trying to say here is words can also mean the opposite effect, meaning that someone can use words in a way that they actually mean the opposite aspect. Okay? This is very important, and I encourage you to look at the decision of Taberville versus Savage. It's a case of 1669, quite an old case, but the principle there is still valid. The facts of this case are that an assailant put his hand on his sword and said, "If it were not for seize time, I would not take such language from you." The victim alleged later on, of course, in court, that he had been in fear that he was about to be attacked. That was the victim's argument. The statement was in fact a declaration, if you look at it, by the assailant, that he did not intend to attack the victim because the judges were in town. So what the decision in Taberville versus Savage indicates is that sometimes words or language can actually mean the opposite, because when you look at the facts in Taberville, the assailant had put his hand on his sword. Okay, so by action, that shows that he was ready to attack. But then the words that the assailant uses actually convey an opposite meaning, which is that if it were not for seize time, I would not take such language from you. So clearly the assailant was showing that he doesn't have an intention to attack because of the specific time being seize time, and that if it wasn't seize time, then he would attack. So meaning that the words were actually showing an opposite conduct. Let's now proceed to look at the aspect of intention. Now, the intention as well as the direct act makes an assault. In this case, there was no intention. That is in the case of Taberville versus Savage. So this is important to note. So that's it, friends, on the first ingredient. And those are some of the important cases which you have to note. Taberville versus Savage being quite an important case for you to note. So let's now proceed and we look at the second ingredient of the tort of assault. The second ingredient is that the act must produce in the victim or the plaintiff reasonable fear. So this is very important. So the act which is alleged to amount to an assault must have produced in the defendant reasonable fear. This is very important. Now, the victim's fear that the threat is likely to be carried out must be reasonable. The aspect of reasonability is very important here. In part, this depends, of course, on a subjective test, which looks at the victim's perception of the situation. How did the victim perceive the situation? And the test here for this ingredient that we use is a subjective one. It really depends on what the victim felt at the moment. For example, it is an assault to point a weapon at a person, though not loaded. So it doesn't matter, even if the gun is not loaded. But if you point it at someone, this is an act of assault. But so near that if loaded, it may do injury. So this is really very important, because if you point a gun at someone, even if it's not loaded, they do not know that it's not loaded. And that action of pointing a gun at someone can raise reasonable fear in them, because for them, on the other hand, they may think that you're going to shoot them. They do not know that the gun is not loaded. So the mere fact that you who is pointing the gun at them knows for a fact that it's not loaded and that you couldn't have hurt the defendant becomes immaterial in such a situation. What then becomes the test is, did the defendant feel any sort of reasonable fear that he could be shot? And the answer is yes, because if someone points a gun at you, you do not know whether it's loaded or not. Even when it's not loaded, even if the person who is pointing it at you is joking, you really don't know that. All you know is that that gun can shoot, and that if it shoots, you can easily die. So such an act can reasonably raise reasonable fear into the defendant. So that's very important to note. Now, the victim in such a case, of course, where you have pointed the gun, perfectly reasonably, and so he may think that he or she is about to get shot. If, however, the victim knew that the gun was unloaded, any fear would likely to be held as unreasonable. So that's exactly what I was talking about. Of course, the situation would be different, where the defendant knew for a fact that that gun was not loaded. Then we can all agree that in such a situation, it cannot be said that reasonable fear has arisen, into the defendant. It follows that the threat must be capable of being carried out. This is very important. At the time when actually the threat is made. In the case of telephone threats, where people call you and they make some sort of threats, the House of Lords in R versus Ireland indicated that the fear should be that the assailant would be likely to turn up within a minute or two. What, however, would be the position if the defendant was prevented from carrying out the threat? What do you think the position would be? Please let us know in the comment section. Because look, friends, we are saying that in R versus Ireland, court held that in matters pertaining to phone contact threats, for example, where someone calls you when they are far away and they start to make threats, whether or not such threats will reasonably raise fear in you, this will depend on whether that assailant is more likely to turn up within a minute or two to execute that alleged threat. This was the position of court in R versus Ireland. But then we are asking, what is the position of the law in situations where the defendant is prevented from carrying out the threat? So let's say, for example, if you are in a house and the assailant is outside, you know for a fact that, the doors are closed, the windows are closed, he's outside, okay? He's prevented by the house or the door being closed and so on. What would be the position of the law? Can we say that reasonable fear has arisen in you so that you fear for your life, especially in situations where the assailant is prevented from reaching out to you directly? For example, like I said, if you're closed out in a house, can we say that reasonable fear has arisen in the victim? Of course, this is a question of fact to be judged on a case-by-case basis. But what is important for you to note on this aspect, please note down the case of Stevens versus Mears. This case is a locus classicus and it illustrates this aspect. The claimant was acting as a chair at a parish meeting and was seated at some distance from the defendant with other people seated in between them. So there were people in between them. This was a meeting and one was acting as a chairperson of that meeting. Now the meeting became angry and a majority of the decision was taken to expel the defendant from the meeting. He then said that he would rather pull the claimant out of the chair than be expelled, and went towards him with a clenched fist. The defendant was stopped by other people before he was close enough actually to hit the claimant. So in fact, he never hit the claimant because he was prevented by the other people from actually hitting the claimant. The general opinion of others who were present at the meeting was that the defendant would have hit the claimant had he not been stopped before he could do so. So that was the general opinion. Now, it is clear that Mr. Stevens' perception that he was about to be hit was reasonable, because this gentleman had charged towards him with a clenched fist. Remember, he wasn't so far away, and these people who were in between there are the ones who were able to stop him. Mr. Mears was in a position to carry out the threat. Now, where the assailant is not in such a position to carry out the threats, the outcome, of course, may be different in the circumstances. But, of course, that case of Stevens versus Mears is very illustrative on what will amount to assault, and especially what amounts to reasonable fear. Because you realize that in this case, actually, there was no contact, there was no actual beating, there was no application of force on the body of one of the parties. But even if this was not there, but the mere charging towards him with a clenched fist, and there being people in between to hold him back, and the opinion of all members who were present who said that if it were not for this gentleman being held back, he would definitely have hit the plaintiff. And of course, it was only reasonable to hold that reasonable fear had been caused into the plaintiff. Let's now look at another interesting case of Thomas versus National Union of Mine Workers, South Wales area. It's a case of 1985, volume 2, All England Reports, page 1. Please look it up. But the facts of this case are that the claimant was a miner who continued to work during a particularly bitter strike. So there was a very tough strike by members of the NAM. The claimant and colleagues were bussed in to work through a large crowd of striking miners who made threatening gestures and shouted threats at those in the bus. Now, court held in this case that there must be ability to carry out the threat, because these people were in a bus, okay? And what is important to note is that there was a line of policemen who were keeping them away. So they were in a bus. First of all, the bus was moving. There were their colleagues or members who were demonstrating and rioting out of the bus or outside the bus. But it's also important to note that there were policemen outside the moving bus who were preventing the miners from reaching out to the people in the bus. So court held that their claim that the actions of these parties who were demonstrating caused reasonable fear in them as to amount to an assault was held not tenable in law. The principle here being that there has to be an ability to carry out the threat. Quite obviously, there was no ability. First of all, the bus was moving. That's one. Two, there were policemen who were preventing the demonstrators from reaching out. So the ability to carry out the threats by these gentlemen and ladies who were demonstrating was not really possible. They did not have much ability to carry out the threats. So court held that in the situation, there was no assault and that reasonable fear could not be raised in the plaintiff. So let's now proceed to look at the third ingredient, which is our last ingredient. And this is that the force used must be unlawful. So what we are laboring to explain here is that the force used by the defendant must be unlawful, because if the force is lawful, then that's not an assault. Now, under what circumstances can assault or the force used be lawful? Of course, for example, where the force applied is, for example, by a result of order of court, or the person who is applying the force has the backing of the law, or they are doing it within the legal confines of the law. Maybe there is a statutory provision that allows them to do so. For example, police officers in execution of their lawful duties. So the assault, or rather the force that they apply in such a situation, if applied reasonably within the confines of the law, would be lawful force. Let's look at an interesting case of Bukenya versus the Attorney General. It's a case of 1986 HCB. And basically what happened in this case, Bukenya escaped from lawful custody. So he escaped from police. And when he resisted the arrest, because police was trying to chase him, so he resisted arrest, and in the course of escaping, he was beaten and re-arrested by police. Of course, he sued for assault and battery, among others, but court held inter alia that his assault was justified in the circumstances, leave alone the battery. We shall look at that later. There's also a class on this channel which looks at the tort of battery. Please look it up, and so that you're able to learn more about that. But as pertains assault, court held that the assault applied on Bukenya was lawful, because this was a police officer who was trying to prevent an escape of someone who was being held lawfully under police custody. And under the Police Act, police officers have those powers to prevent someone or a suspect who is running away from custody. So court guided and held that there was no assault, and that the force used by the police officer to prevent Bukenya from evading the arrest or trying to rearrest him was in fact lawful force. So basically, friends, that is it pertaining to the tort of assault. We have been able to define what this tort is. We have looked at the ingredients and the most important cases that you must know as a student or someone who is trying to learn about the tort of assault. Once again, I encourage you to subscribe to my channel. This is very important, because when you subscribe, you'll not miss out on such important videos. And also share this video with your friends so they are also able to benefit. And students interested in private law tutorial sessions, please feel free to reach out to us. Our numbers are down in the description box. And of course, it has been proven over and over again that students who do not have any sort of mentorship or do not have any guidance from the experts tend, of course, not to perform well, especially where you are busy or you're trying to work. As you're studying, you'll always have those challenges. And if you have these private law tutorial sessions, you will quickly realize that you'll be able to improve on your grades and also your understanding of the law. So we meet again, guys, in another class.